and sort of odd looking at the definition of claim as a whole. I think that everything else dealing with a civil process, and then suddenly we jump to criminal procedure without any explicit signal that we're doing so. And so if you take the total landscape of it, the total context of it, it seems to me that the association that your provision has is a civil association.
Well, Your Honor, I think that is expressly rejected in the authorities that we have cited. I frankly had never known about Justice Scalia's book before I started reading the cases in this appeal. But the Maryland Court of Appeals is both quoted it and relied on it for exactly this point that the or means forget all of that. That's different. That's disjunctive. You're not supposed to read those together. And then there are several other, basic canons of construction, including, most importantly, the way it starts off saying any of the following. And no case that they're citing that says, in support of this justum generis argument, is leading off with that saying any of the following. There could be no clearer expression in English that those subclauses separated by semicolons, which, my English.
If you take that line, so you still come back, say, well, this applies to a criminal process or demands for relief in criminal process. And I think I could see my way there in the case even more easily in the case of a subpoena. A subpoena, ducis tecum, is at least a written demand made upon the insured, whether it's to follow up on what Judge Keenan was saying. I'm not sure it's a demand for relief. In other words, the problem you have, I think, with your definition is that there are three elements to it, at least. One of the elements is that it has to be in writing. Another element is that it has to be a demand for relief. And another element is that it has to be against the insured. And whereas I think you might get somewhere with the first item and the first element, which is that it is written. I'm not so sure that you fare as well with the other elements. I'm not sure that it's a claim against or a demand against the insured. I'm not sure that it is a request for relief. It seems to me that you have a number of hurdles to satisfy all the elements in that definition. So why don't you can respond to that, of course, and you've got some time for rebuttal, but we've given you some extra time. And
thank you, Judge.
Why don't you come back and give this in rebuttal?
Very well. Thank you.
All right. Ms. Wellington.
And please the court, Katie Wellington on behalf of Federal Insurance Company. To win on appeal, appellants have to run the tables. They have to show that the expenses they ask federal to cover meet both the definition of a claim and the definition of a loss. But appellants can't make that showing. As the district court correctly and persuasively explained, under the plain text of the contract, a search warrant isn't a claim because the contract doesn't cover criminal proceedings. nor is a search warrant against an insured. It isn't against anyone at all. It directs a law enforcement officer to search a place and seize a thing. And a search warrant isn't a form of relief. It's the government's investigation of a potential crime. The expenses appellants seek related to the search warrant aren't for defense costs. They're for affirmative relief that they chose to seek in court. The same is true of appellants' requests for reimbursement related to the conflict letters. Those letters don't make a claim, and appellants don't seek defense costs. The conflict letters simply apprised appellants of the government's position, which appellants did not dispute. This court should affirm. So I wanted to start with the warrant issue, and in particular, the issue that the court has raised, that this wasn't a claim against and this is a longstanding principle. This isn't a technical question of what a search warrant is. It's what a search warrant has always been. The U.S. Supreme Court explained in the Zurcher opinion and in the Anderson opinion that search warrants aren't against a defendant. And this is an incredibly important point because in the context of the Fifth Amendment, the right against self-incrimination, if a search warrant was against a defendant, then those documents couldn't be introduced into court.
So the defendant is not particularly pleased that the search warrant has been issued.
That's correct, Your Honor, but that's not the question here. The question here is the search warrant against an insured? If you look at the plain text of the warrant, that's at JA 53, it commands authorized law enforcement officer to search and seize property. It's not.
With respect to the point I was making about this being possibly confined to civil cases, I don't think that's your most important point, but aren't there some applications of this provision in the criminal justice process? For example, if you're the insured received a subpoena, would that still be covered by the policy, even though it was a criminal matter?
So that wouldn't raise the same question we're talking about here. It would be against an insured, but we don't think it would meet the definition of a claim because—
I'm asking you, how would you come down on the question of the subpoena?
So we don't believe subpoenas would be covered under this definition of claim. Now, there's a separate subpoena enhancement in this contract that does cover subpoena-related costs. But the definition of a claim here very clearly refers to civil proceedings if you apply the Noscitur Associates canon, which is applied under Maryland law. And you look at each part of this definition of claim. First, you have a written demand or written request for monetary damages. That's a form of civil relief. You have a written demand for arbitration. That's a civil proceeding. You have a formal administrative or civil regulatory proceeding, and you have a civil proceeding. All of that talks about civil proceedings. Under Maryland law, you look at the contract as a whole, and you apply canons of interpretation, including justum generis and Noscitur Associates. And the government employees insurance case, this is cited on page 19 of our brief. That's a Maryland case. It applies the justum generis canon in a contract that uses a disjunctive or, and where the term you're trying to interpret is at the beginning rather than the end of the particular provision at issue. So I think under Maryland law, you do look at all these terms together, and the only conclusion here is that criminal proceedings aren't covered. So we don't think a criminal subpoena would be covered here under the definition of claim. We also don't think that you need to reach that in order to decide this case.
But there's no exclusion in this definition of claim of the criminal justice process.
There's no express—
You're the one that wrote the policy.
So under Maryland law, you don't use exclusions to interpret the scope of coverage. You look at the text of the coverage provision itself, and you apply these ordinary canons of interpretation. So we think the criminal proceedings are excluded, but even if you disagreed with that point, we think it's still not covered because a search warrant isn't against an insured, because it's not seeking relief for a wrongful act. This goes to your question, Judge Keenan. The search warrant isn't seeking some kind of remedy based on the claim here, which is an obstruction of justice claim, an allegation. And instead, it was simply seeking information to investigate what was going on in those criminal proceedings. So we don't think, for several different reasons, that it meets the definition of a claim here.
Maybe your point is stronger with respect to the words demand and relief than it is with respect to the word against. Because they are in a, you know, the officers and the insured are obviously pitted in an adversary situation.
So we think the question is the search warrant against the law firm? Is it against the criminal defendant or someone who's about to get indicted? And under longstanding Supreme Court precedent, under the basic understanding of the search warrant, under the plain text of the search warrant in the record here, we don't think that it was against the insured here, and that's the relevant question. We also don't think that the costs that were expended here were defense costs. They came into court and requested affirmative relief with respect to a particular privilege review process. And that's similar to a countersuit or, with Garcia case held that a motion under Rule 41G for return of property.
Counsel, I think maybe at this point, it's good just to see if the panel has some questions of you with respect to the points you've been making. Judge Thacker, do you have any?
I do not.
Judge Keenan, do you have any questions?
No, thank you.
Right. I have no questions, so thank you very much.
Thank you.
All right, Mr. Richards, we've mentioned that you had some time in rebuttal.
Thank you very much, Your Honor. In terms of whether it was against Frost, Brown, Goldstein, Levy, and Joshua Treem, it was against it enough for this court to find that we were being irreparably harmed and reversing the search warrant order. So clearly it was against us and we had standing to challenge it. We did challenge it. We challenged it according to the rules. That was not some sort of voluntary, oh my goodness, I went out and filed a lawsuit against somebody. We had been
Problem is, it was not a written demand against the insured. It didn't require the insured to do anything. The insured could have just sat there.
I respectfully disagree, Your Honor. I think that as have any number of other courts, we believe that it was a demand to.
You believe that, but you're not showing me. You're not showing me where the written demand on the insured is.
Well, in addition to the search warrant, if you choose to disregard the search warrant, there were the demands that Joshua Treem stop representing his clients and that he, come into court and get, formal waivers if he continued to represent them. Those were clearly written demands to him, requiring him to take action. Your Honor, when we broke before, you had been asking a question about subpoenas. And I think one of the things that, and we spent a lot of time talking about subpoenas here, but this very insurance company, this litigant, had previously litigated that issue in Maryland, and Judge Motz ruled that a subpoena was, AG subpoena was covered under this exact language. So it was not excluded because it wasn't civil.
Where is the demand language in the letter about the conflict? That's the January 11th, 2019 letter. It says we write to advise you, and then it closes with, please advise us promptly. Is that the demand? Please advise us promptly?
I think a normal layperson would understand that when a prosecutor says, you were disqualified, let me know if you're not going to do this. That's a demand. Yes, I do think
A
that.
demand to do what?
To withdraw as your counsel for the person that you have been representing.
That's a quite polite demand letter.
There are lots of
Anyway, go
very
ahead.
polite demand letters, Your Honor, but, I think fundamentally our point comes down to this. Under the McGonnell case, which is the controlling case in the Court of Appeals, now Supreme Court of Maryland, an insurer must use clear and unambiguous language to distinctly communicate the nature of any limitation on coverage to the insured. Here we have a situation where they've known before, because they litigated and lost the subpoena issue 2 years before they issued this policy, and didn't go and change the policy to insert only civil for more non-monetary relief. No, they'd litigated it, they'd lost, and yet they would like this court to affirm based on the notion that, oh no, it's only civil, no criminal coverage that we sold to this criminal defense firm. I think that falls well within a reasonable reading by a layperson to think that this clause, which has been repeatedly found to cover search warrants, indictments, target letters. This court found in the Bornstein case that a target letter was requesting relief. There's no real response to that. We got a target letter. And
yeah, but the search warrant is what's at the heart of this case, and the Bornstein case did not deal with a search warrant.
The search warrant has certainly been the heart of much of the briefing of the case.
Search warrant is at the heart of the argument here. And the Bornstein case didn't involve that.
It did not involve the search warrant. You're right.
Well, thank you, sir.
Thank you very much, Your Honor.
For COVID reasons, I'm not shaking hands this morning, but that doesn't mean I'm any less appreciative of your good argument. We will we thank Judge Keenan for sitting in with us, and we will take a brief recess and reconstitute the panel.
This honorable court will take a brief recess. The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Kindly be seated. All right. The next case is FTC versus Yulin, and Mr. Shanghai,
So, Mr. Singhal, sorry.
happy to hear from you.
Thank you, Your Honors. May it please the court. My name is Kyle Singhal, and I represent the appellants. This court should reverse the district court's denial of the motion to intervene and the motion for relief from judgment, because the district court abused its discretion in denying each of those motions. Appellants are a group of unsophisticated investors who invested $2 million or so in what they thought was a real estate development in Costa Rica. Turns out there was a broad fraud, chiefly centered in Belize, and appellants' money was swept up in its takedown. The FTC now, the very agency that purports to protect victims of such consumer fraud, now accuses these victims of seeking to cut in line in front of the Belize victims, even though appellants should not have been in that line to begin with. Broadly speaking, there are 4 issues: 2 on the motion to intervene, jurisdiction, and the requirements of Rule 24A, and 2 on the motion for relief from judgment, the applicability of Rule 60B-5, and the merits of the constructive trust claim. I would intend to start with jurisdiction and go in order, but I welcome the direction and questions of the panel. Turning to jurisdiction, the rule from Griggs and Doe is that when a party files a notice of appeal, that divests the district court jurisdiction over that party's litigation. The same is not true when the party that files a notice of appeal is different from the would-be intervener, as in this case. None of the cases cited from this court support the FTC's proposed rule that the would-be interveners here cannot bring their claim because the district court lacks jurisdiction.
Complicated than it needs to be.
Well, particularly when it's
The case up on appeal, normally the presumption is the district court leaves it alone.
leaves alone the aspects of the case that are on appeal. However, the district court undisputedly has continued retained jurisdiction over the receivership in this case, and it has been exercising that jurisdiction throughout the pendency of the appeal. Moreover, in cases such as in appeals arising under Rule 54B or 1292B, interlocutory orders even, there is dual jurisdiction with the district court and the Court of Appeals exercising jurisdiction over different aspects of the case, particularly when they involve different parties at the same time.
Not sure how this case can be parsed quite that cleanly.
The issue is whether the district court had jurisdiction to entertain the motion to intervene. Nothing about that intervention motion itself overlapped in any way with the appeal that was pending in this court at the time that motion was filed. Certainly, the district court at least had jurisdiction to rule on the motion to intervene, even if it may have believed that the merits of the constructive trust claim somehow overlapped with the appeal. I would note that this court's decision that resolved the appeal a few months ago says nothing about Newport Land Group, about our clients, about their money, or even about Costa Rica, which supports the idea that nothing in our claims overlaps with the issues that were on appeal.
What it suggests is that your people didn't appeal.
And
What it really suggests.
Yes, Your Honor.
That case wasn't in front of us.
That's right. That's right.
So it was their decision not to intervene and their decision not to join in the appeal.
And we readily acknowledge that our clients didn't intervene until they filed these motions after AMG. And they did that because they thought, the honest to goodness thought, that the district court would, when it reevaluated the defendant's liability on remand from the principal appeal, would give them a seat at the table and see if they could get their money back out of this receivership that it should never have been in the first place.
I understand that, but
Yeah.
clients and lawyers too often make miscalculations.
Right.
And that's what they did here.
In
Choice.
some of
They
the
could join the case when it was live or not, and they decided not to. They decided to wait, according to you. Maybe they didn't know about the case, but they don't tell us that. Your position is they made a conscious decision to wait.
Well, I can't take the position that they didn't know about the case. They knew about the case. Sure. But they didn't know that they were supposed to file a Rule 24 motion to intervene.
Well, and were they represented?
Only briefly in California before NLG was made a party. Right. But to be fair,
no, because I didn't have a lawyer.
Well, right. They had a bad lawyer, and we admit that. But they had a bad lawyer at a time when NLG was not yet a party, and so their decision to file a lawsuit in state court isn't as maybe laughable as it seems in hindsight. At the time, these were people who were largely from California. They'd invested in California, and they had no reason to know as lay people that they needed to file a Rule 24 motion in federal court in Maryland.
Judge Moss touches upon a little weakness in your case here, and it's all over the matter of timeliness. And you decided to take you gambled. You decided to bring your claims against NLG in state court in California, rather than litigate in the case before Judge Masidi. And then when the California case didn't pan out to your liking, you said, oops, we're going to jump the tracks and get into this case. Well, a lot had happened in this case while you were fiddling around in California. And it had sort of been wrapped up. A receiver had been appointed. Some of the money had been distributed to the victims of the Sanctuary Belize scam. And there was an awful lot of water over the dam. And so you come in, the investors come in at the last minute and said, oh, we're entitled to some of this money too, which of course would embroil the receiver in additional proceedings, making additional expenses, causing the victims of the Sanctuary Belize trial to have to wait for relief. It just seems to me that it's a little late in the day for you to be jumping into this matter. Even if it wasn't late in the day, your intervention is sufficiently different to raise the question of whether this is a complicated matter, to say the least. And having an intervenor, the investors in NLG being an intervenor, is going to make a life a perfect mess and a very complicated mess for Judge Masidi. And so it just seems to me that, you took your chances, they didn't pan out for you. Now you come in and going to want to intervene in a manner that's going to work to the disadvantage of all those who had litigated the case from the start and were expected to receive some funds from the receiver dealing with the Sanctuary Belize scam.
Your Honor.
And your problem is you prejudice all the people that were there in this litigation in a timely fashion. You just prejudice them.
Your Honor, if I may respond to that in a few parts, there are three factors, as Your Honor knows, in timeliness: how far along the suit is, prejudice, and the reason for delayed intervention. I'll go to prejudice first. Just to be clear, two of my clients of the appellants are in fact lot owners in Belize and are victims in the Belize scam as well. So in terms of prejudicing other victims, they're also victims of that scam. Second, you said entitled to some of this money too. Our position on the merits is and has been that appellant's $1.95 million should never have been in that pot of money to begin with. It's a windfall to the FTC, and perhaps if any pennies on the dollar trickle down to the victims of the Belize scam, a windfall of a few pennies there as well. As to how complicated the matter would be, not particularly. In our motion to intervene, we identified, which is what Rule 24 says to do in our motion for relief from judgment, that we sought relief in the form of return of our funds from the receivership. And it's not particularly complicated to rule on the matter of law that our clients were the beneficiaries of a constructive trust. In fact, for that, we cite the Kim case in our brief. on page 33 and 34 of our brief, and the FTC didn't respond to that whatsoever. So we would argue that point has been conceded. And that matter of law is fairly straightforward, following the Kim case, which is fairly analogous to this one. And finally, as to the point that our clients gambled and lost, that language was used by this court in the Alt case, where the would-be intervener there admitted that they gambled and lost. Here, our clients had no idea what they were doing, and that is the record is distinct in that there was a factual admission on record that the would-be interveners gambled. Here, there was not much of a gamble. They were hoodwinked into following the bad advice of a lawyer in California to file a suit. Then, now, and one more point I'll make about that, and then I'll leave it alone, is when the district court held a bench trial in this case, one of the
this whole thing isn't complicated, but trying to figure out what the relationship of the NLG investors is. Those may differ from individual to individual. I don't know who, we don't know at this point who was defrauded by NLG and who was not, whether they investigated the property and who didn't, and who is due what and who is not. You say all that's not complicated?
No, I don't think there's been much opposition to the idea that that the appellants invested $1.95 million, and the judge himself said that money was frankly irrelevant to the Belize case, and yet the money was taken into the receivership. So as to prejudice, I think there's very little. One more point I would make as to why they should not be dinged for failing to intervene in 2018 or 19, and that's that the district court himself didn't ding them for that in 2020 or 2021 when he invited letters or motions from the appellants. Following the bench trial, when the district court issued its opinion in August 2020, the district court said, I invite at least David Hyman, who would come to testify, to send a quote motion requesting return of his funds. Nothing mentioned about a Rule 24 motion. There is no such thing in the FRCP that would contemplates this motion for request. And so it's hard to fault the movements for not knowing that they were supposed to file a Rule 24 motion when even the district court telling them what to do didn't tell them to do that, and didn't then hold it against them that they had not intervened in 2018 or 2019. Only after we filed the motion to intervene did it become an issue that the appellants had not previously intervened in 2018 or 19. Up until that point,
we have to look down the road in this business, and if we reversed a district judge for abuse of discretion in denying a motion to intervene that was filed after the litigant had litigated elsewhere, 8 months after an AMG case came down, on the advice of counsel, it is, what is the impact on district judges across the circuit of something like that?
Very slim.
Excuse me. They're going to say, no matter how untimely your motion to intervene, no matter how uncertain and speculative your interest in the case is, you've got to grant the motion to intervene. And that complicates litigation in this circuit to quite an extent. It would be received by the district judges in this circuit, by many, the bar in general, as a wet cat on the table.
Your Honor, I see that I'm out of time. Would you?
You've got some time for rebuttal, okay?
Can I just put something to you before you sit?
Yes, please.
Let's take away the rights and wrongs and strategy or whatever of your client and your actions, and go back to your first point about jurisdiction. And you seem to think that the court was wrong in saying it had no jurisdiction to issue this. I think if you read carefully Public Citizen, you will find that the jurisdictional ruling was correct. And if the jurisdictional ruling is correct, you're out of court. Now, we'll listen to what the government has to say, and then you can come back and tell me why I'm wrong on that. Okay?
Thank you, Your Honor.
Thank you.
Yeah,
Good morning, Your Honors. May I please the court?
Is it-
Matt Abiad from the Federal Trade Commission.
Is it possible you could start with jurisdiction?
Absolutely, Your Honor.
Thank you.
The district court at the time certainly did not have jurisdiction to rule on the motion to intervene because what appellants sought from their intervention was to seek relief from the default judgment against NLG, which itself was on appeal. They sought to extricate the NLG assets from the receiver. That order was also on appeal before this court. As therefore, the easy answer to the jurisdiction is, imagine if the court took the case, the district court took the case, allowed them to intervene, ruled on the motion for relief, and granted them relief, when at the same time, on November 1, this court affirmed, which would have two contradictory decisions by two courts.
And that's a fine theoretical
Correct.
argument.
Correct.
But what I'd like you really to talk about is the case on which they rely in saying that and that's the public citizen case,
Correct.
which I read a little differently. And so how would you distinguish, or how would you tell us that public citizen doesn't do what they say it does? Do you remember public citizen? I mean, I know there's, as Judge
Absolutely,
Wilkinson
Your Honor.
said, there's a lot going on here.
But if I may, public citizen said exactly, if there is a motion to intervene, when the relief that the interveners are seeking is an issue before the Court of Appeals,
Right,
then you have to deny the motion to intervene.
right.
There is no distinguishing characteristic between the two cases. But if I may, because the district court denied their.
Well, what they read it as is when a putative intervener filed a notice of appeal, the district court then lacks jurisdiction to entertain an intervention motion by that same party. See, they limited, and they say that that's the only holding. In other words, you're limited from intervention by that same party. The person that's appealed, I guess. I don't know.
But I'm sorry, Your Honor. A person who has not intervened, how would they be an appellant?
When a putative intervener,
It's a putative.
although it is true as a matter of fact, consumer groups who moved to intervene in public citizen were the only consumer groups that noticed an appeal.
Right.
The public citizen majority did not indicate that this was a relevant fact, I think. And that's what they say, that is the holding a public citizen.
Their argument is if they were not parties, then the rule does not apply to them.
Correct.
But the whole point of intervening in Doe versus public citizen was that it was intervention by non-parties. I'm
Right.
sorry. And so I don't think you can get away from that holding. The whole point of intervening is to become a party. And so as long as the relief you are seeking from your intervention is an issue before the Court of Appeals, then you cannot intervene. And it makes perfect sense. Again, in the hypothetical I posited, if the court had granted them the motion to intervene and entertained the motion for relief and granted them relief, when this court at the same time, in fact, affirmed.
Right. I understood you.
That's why they could not do that. But that's not the only thing. Even if we go past the issue of jurisdiction, because this court did, in fact, in November, finish the appeal, and the case is now back before the district court. Even on the merits of that intervention motion, they failed to satisfy every one of the requirements. And there was a lot of talk about the timeliness, the gross untimeliness of their motion. But there's another, probably more substantive reason that they do not, that they cannot intervene, which is their interest in the subject of the litigation. It's not that the rule for intervention is not that any party that could win or lose something from the outcome of the litigation would satisfy that interest. This court's decision in Gould v. Alico makes perfectly clear the interest has to be in the subject of the litigation. The subject of the litigation here was the fraud that related to the sanctuary Belize development in Belize. You heard my friend freely admit, and they've admitted in their papers, they had nothing to do with sanctuary Belize. Their interest is simply they invested in a different development in Costa Rica that NLG was supposed to manage. And now they're concerned that after the litigation in sanctuary Belize, there'll be no money left for them to pursue their claims against NLG for fraud. This is exactly what Gould v. Alico said. That interest does not qualify under 24A2. If you recall, in that case, it was bondholders that were seeking to intervene because they were concerned in a securities fraud litigation. They were concerned that the stock class members in their litigation, there'd be nothing left for them.
Yeah, so let me ask you on that. It seemed to me that Judge Massidi his ruling had two parts. He says, first of all, there's no jurisdiction. Second of all, he said, I don't have jurisdiction. He said, even if I do have jurisdiction, this is going to be denied. In other words, he wasn't going to let them in. He wasn't going to. He has struggled so long with this case, and it's a complicated piece of litigation, and he was not going to let them in.
Absolutely.
And I think wisely and correctly so. And to me, the question of jurisdiction, it bottoms out on how much of an interference is it with the Court of Appeals adjudication for the district court to rule on an intervention motion before the trial court? What are the potential risks of interference, of having the case go off on two tracks, of contradictory rulings? And if you look at that risk of interference with the Court of Appeals function as a bottom line, I think that there's as you have pointed out in your argument, I think there's a risk of interference here.
Absolutely.
And that's why I think, that it was wise to let us decide the appeal and not get in the middle of it with a ruling that would complicate things even further. And then if you do want to take the extra step and say, even arguendo that there's jurisdiction, which has all kinds of problems holding that there's jurisdiction, to say that he abused his discretion, given the untimeliness of it.
Well, so
Right.
it strikes me that timeliness is at the heart of the jurisdictional argument. So suppose they had moved to intervene while this was still in the district court.
Right.
District court would have jurisdiction. It would be timely. And then what?
It could have been timely, Iman. But even if they did, that's a great question. Let's say that their intervention happened before the notices of appeal were filed.
Right.
And the district court had jurisdiction and was willing to entertain their claims. There are two things to point out here. First, the district court ruled against them on the merits of the intervention because their interest simply does not qualify under 24A2, as this court's precedent in Gould v. Alico shows. Two, bear in mind that the district court, in fact, had considered the merits of their claims in its second memorandum opinion and said, no, you do not get to jump the line ahead of the victims of the fraud. The appellants here are merely investors, and they want to jump ahead of the people who were defrauded by the company they invested in. And the district court said no. So they lose on the jurisdiction, they lose on the timeliness, they lose on their interest because they do not have a recognizable interest, and they lose on the merits.
This is kind of academic, but let's give them back timeliness. So they move to intervene, not after the district court has done these various motions, but just in the very beginning.
Yeah.
Then what?
Then they have to show that their interest in the subject of this litigation qualifies them to become parties. The Gould v. Alico precedent completely forecloses that argument for them. Their interest as investors in NLG does not qualify under 24A2 to allow them to become parties in the sanctuary release.
Court's conclusion is subject to review for what?
I'm sorry, which conclusion?
This hypothetical conclusion where they moved to intervene before the district court had made all these rulings. And so it was timely.
Right.
And
it's still abuse of discretion. The review of the intervention is for
okay.
If I may just point one thing out on the jurisdiction. We obviously continue to believe and hold the position that the district court at the time did not have jurisdiction. But the district court did go ahead and also rule on the merits of the intervention. And I would ask this court to certainly rule on the jurisdiction, but if you stop there, then you're leaving yourself or leaving everybody, the district court, Judge Messetti, open to another motion to intervene now that the case is back before him, only to go back up with exactly the same arguments. So we would ask that the court certainly rule on the jurisdiction because it is an important point to me, but to also reach the merits of the intervention. And
of course, if the court didn't have jurisdiction, I mean, in other cases, take not this case, we usually don't rule up or down on the rationale in which the court improperly exercised jurisdiction.
Absolutely right, but there is a way for this court to do that. In the Doe versus public citizen case, the lack of jurisdiction on the district court's part is not a subject matter jurisdiction. It's a jurisprudential kind of jurisdiction.
What kind of?
Jurisprudential. It's to make sure that we don't have two courts deciding the same issue. And so this court in Doe did recognize some exceptions where it can reach the merits. One of those exceptions is, it says, when that would promote judicial efficiency and facilitate the division of labor between the trial and the appellate courts. And it cites two examples, the Little versus Griffith case and the Fobian versus Storage Tech Corporations, as examples of where, when we're talking about not subject matter jurisdiction, but jurisdiction of the jurisprudential nature, that this court can reach the merits as well.
But there isn't, I mean, the overall interest to me seems to me to keep this litigation, which is vastly complicated on its, as it is.
Yes.
From becoming even more complicated and more bogged down with two different sets of investors and companies and whatever, and the receivership's resources and the rest. And what you're saying is that it is permissible to say that there's no jurisdiction, and because it's a jurisprudential ruling, there's no abuse of discretion. And that's the step that will spare us another appeal. But not only that, we'll keep this already complicated piece of litigation from becoming even more so.
Absolutely, Ron. That's absolutely right. And if I may, as to my friend's point that this is only a legal question that the district court could rule on their claims, nothing could be further from the truth. First, their claim, even though it has really nothing to do with this litigation, their claim is against NLG, that NLG defrauded them when they made their investments. That they made their investment thinking they were making it for a project in Costa Rica, but NLG and the individuals that were the head of that common enterprise basically used all of that for the sanctuary beliefs. Those claims against NLG, they have two theories of remedy: the constructive trust and the contract. There is so many factual findings that need to be done on those two claims, even if the court were to entertain it. You have to show, in fact, there was fraud. Each individual of any of the appellants, you have to go into the circumstances of their individual investments, what representations were made to them.
It's the worst morass you could think of.
Absolutely.
You just can't think of
Absolutely.
of a worse morass. But I come back to your point that if we find there's no jurisdiction, that we do have some flexibility, because there are jurisdictional rulings that put the federal courts in a posture of contradicting what Congress said with respect to diversity and federal question jurisdiction. But the question here on intervention is a little bit different. It deals with relationships between the appellate courts and the district courts within the federal judicial system.
Correct.
And that kind of jurisdictional question involving the interplay between federal appellate courts and federal district courts is something where we have a greater degree of expertise, and in addition, doesn't run the risk of a conflict with Congress over grabbing a piece of grabbing a piece of a suit in violation of the diversity of citizenship, or taking a purely state law case without a federal question. Those bring us into conflict with Congress.
Correct.
The jurisdictional ruling here does not.
Correct. That's exactly right. And that's where the exceptions that this court in Public Citizen pointed out to could help this court reach beyond the jurisdictional impediment. And it's only because the appeal had been decided. That's what makes this possible. That because the appeal was decided, the lack of jurisdiction was temporal for the district court. It was only because at the time there was an appeal. Well, now there is no longer an appeal. So if the case were to go back to the district court now, the district court would have jurisdiction to entertain it. And then its decision on the merits of the intervention motion would become then appropriate and proper for review of this court. And therefore, we ask that this court affirm both on the lack of jurisdiction, but also affirm on the inappropriate intervention of these appellants. And if there are no more questions, I thank you, court.
Thank you, counsel.
Thank you.
Mr. Singhbal.
Yes, Your Honor. I may first on Judge Motz's question about Public Citizen. My reading is that Public Citizen was a non-party when it appealed a sealing order and an order allowing Company Doe to use a pseudonym. And when it went on appeal, it had non-party appellate standing. All right, so it wasn't a party, but it was the same entity, Public Citizen, who filed a motion to intervene in the district court. It's the same person, the same entity, filing both the notice of appeal and the motion to intervene. And in that circumstance, the district court lacked jurisdiction over the motion to intervene.
Those are the facts of that case.
Right.
But what you want to do is to limit the holding to the facts. I mean, lots of cases have different facts, but the same legal principle.
Yeah, I would take the opposite view, which is that expanding that to a case where the motion to intervene has nothing in common with the appeal is an expansion of an apparent limit on jurisdiction when it's still undisputed that the district court has jurisdiction to administer the receivership. And so for that reason, we don't quite follow the argument that there's no jurisdiction at all to entertain this receivership related matter. And it seems clear that nothing this court could have done in the Puckey appeal would in any way conflict with our client's claims. Second, as to the impact on lower courts, one thing this court could do in ruling is it could identify the errors of law that the district court made in its opinion. And we know that errors of law are abuses of discretion. So on page 9 of the district court's opinion, it misapplied the prejudice prong of the intervention analysis. And it said that we don't look at the difference between prejudice now and prejudice if we had seen the intervention earlier. We'd look at prejudice full stop. That's an error of law. In Gould, the court said you look at the prejudice caused by the delay. And so that would be an error of law. There is no prejudice caused by the delay. Second, the district court erred as a matter of law on page 17 when it held that our clients were, quote, mere potential creditors. Now, admittedly, that requires taking a look at the merits of the constructive trust claim, which I can imagine this court would be reluctant to do. But the holding that we are mere potential creditors is incorrect and inconsistent with the record that was before the court. In terms of the impact that this would have also, this court could make a narrow ruling that looks at the particular language that the district court used, both when it invited responses following the issuance of its August 2020 opinion and when it rejected the responses that it received in its January 2021 opinion. At no point then did it hold against appellants that they had failed to intervene in 2018 or 2019. And again, appellants argue that when the district court stated in footnote 20 of its August 2020 opinion that it would reconsider liability on remand, that provided an opening for them to enter with minimal prejudice and with minimal harm from the delay to the district court and to the litigation. We therefore ask this court to reverse both on jurisdiction and on the merits of the motion to intervene. Thank you.
Thank you. We will, you want to shake hands with the council?
We could send them up to you. We can send them up to you after we shake hands.
Okay.
Okay.
All right. They may not want to come.
I know, he has a big stick. So. Good morning.
I just may have a moment. May it please the court. My name is Mahesha Subbaraman. It is my privilege to represent Social Security claimants Barbara Rush, Cynthia Parker, and Vanessa Nwobi. At issue today is proper interpretation of the Federal Vacancies Reform Act, or FVRA. The FVRA imposes a 210-day limit on how long acting officers may fill a vacant office, subject to an exception for when the president submits a nomination to the Senate for the vacant office. Claimants maintain that this pending nomination exception did not apply to acting SSA Commissioner Nancy Berryhill because President Trump made a nomination after the 210-day limit expired. Yesterday, the Eighth Circuit rejected this argument. I'd like to explain why the Eighth Circuit got it wrong.
Well, in fact, everybody's rejected the argument now, right?
Well, not entirely, Your Honor. I mean, the Eighth
There's some
Circuit,
district courts.
right. District courts have embraced the argument. The Eighth Circuit reversed the leading decision on that, Brian TD. So within the Eighth Circuit, this argument has been rejected. There are other district courts that are currently considering the argument. It remains to be seen whether they will embrace it.
Well, but the bottom line is that the Eighth Circuit opinion is not particularly helpful.
Your Honor, I'm not going to pretend that it's helpful, except to say that I think that when you read the opinion and you identify the errors in it, it then becomes helpful for our position.
To say something about it, but when you received the Eighth Circuit opinion, your reaction was not one of glee.
No, Your Honor, it certainly was not. But I think part of the reason for that is because, with all due respect to the Eighth Circuit, it cut a lot of corners to reach the conclusion that it did. And I'd like to explain what some of those corners are.
To come back to the bottom line, in addition to whatever other mayhem would be raised by your view, you would invite us to create a circuit conflict?
That's correct, Your Honor. And I think that this court has been more than willing to create a circuit conflict or to contribute to one, to the extent that that was what the...
I mean, we do, but you know, we don't do so gratuitously. And where there's federal law and where there's an interest in maintaining uniformity, as there is without question here, because it deals with the way in which, with the powers that acting commissioners and others have. This is something where uniformity of federal law across the country is an interest to be weighed on the scale. Now, if the Eighth Circuit were terribly and horribly wrong, the uniformity interest wouldn't be paramount, I suppose, but all things considered, it's nice to have the different regions of the country dealing with these cases in a similar way.
Your Honor, I'm not disputing the general value of uniformity, but I think it should be a genuine uniformity rather than a uniformity which leads the Supreme Court to reverse, in which case we end up with a situation where courts and the executive branch, relying on the erroneous decisions of multiple courts following one after another, have to undo decisions as a result of that. So if I may speak briefly to what I think the Eighth Circuit got wrong here, I think it becomes apparent why this court should reject the Eighth Circuit's analysis in much the same way that the Eighth Circuit, the Fourth Circuit rejected the Eighth Circuit's analysis when the initial round of litigation surrounding appointments clause claims by Social Security claimants came to this court in the Probst case, and the court was looking at the question of whether issue exhaustion was required. The 10th and the 8th Circuits took the position it was required. This court disagreed with them and said it wasn't. And we're asking the court to do something similar here. Let me explain why. When it comes to 3346A2, the Eighth Circuit essentially treats this provision, which spells out the 210-day limit and the pending nomination exception, as the beginning and end of its analysis. And what it gets wrong is that it fails to realize that this analysis isn't about one statutory provision, it's about two provisions. Now, Section 3346A2 addresses what happens when the president nominates someone during the 210-day limit. It doesn't address what happens when the nomination happens after the 210-day limit. Section 3348B1 answers this question, and it says when there's a gap, that the office is to remain vacant. And we submit that that text bars a nomination from reviving a past serving acting officer. Now, if you look at the Senate's original draft of 3348B1, it expressly said in the Senate committee report, if the president does not submit a first nomination to the Senate to fill a vacant office within 150 days after the date on which a vacancy occurs, the office shall remain vacant until the president submits a first nomination. Now, the committee report expands on this point, saying the bill's enforcement mechanism is to make an office vacant if 150 days after the vacancy arises.
Dealing with the committee reports rather than the text of the statute.
Well, the reason I'm dealing with the committee report is because the Eighth Circuit ended its analysis by saying, we don't usually look to legislative history, but if we were to look at it here, the only difference between 3346A2 as it was finally enacted and the draft provision of it was the change in the number of days. And what the legislative history shows is that there's actually a pretty big difference between what the Senate was looking at when it said that this statute allows for the revival of acting officers after the
Still, you know, it may be outmoded of me, but I still think you have to start with the text of the statute.
I'm happy to, Your Honor. So let's go to the text of the statute. But just to kind of close the point on the committee report, what the committee report was saying is that the sanction can be ended if the president submits a nomination. So we think the text of the statute that's relevant here is 3348B1, not so much 3346A2. But to turn to 3346A2, the Eighth Circuit says that 3346A2 enacts this freestanding pending nomination exception that allows the minute the president submits a nomination, an acting officer, even if they've served out 210 days, they come back the minute that nomination occurs. That analysis is problematic for two main reasons. First, the Eighth Circuit says that there's a disjunctive or that separates 3346A1, which spells out the 210-day limit, and 3346A2, which spells out the pending nomination exception. A disjunctive or means that you can either have option A or option B. You can stay or you can leave, but you can't have both. And what the Eighth Circuit's own analysis seems to be doing is turning the word or into and, because what they're ultimately concluding is that Berryhill could serve 210 days.
Where is the statute? There's a big gap in a big gaping hole in all of this, because where is the provision in the statute that disqualifies someone who has served in the A1 period from serving in the A2 period? Now, if it seems to me that that your position is asking us to put a gloss on the statute, I would have expected, if your position was what Congress adopted, that we could point to some language saying that once you serve the 210 days, you are in some ways disqualified from serving thereafter. And I don't see that.
Well, Your Honor, that's the language in 3348 that I started my remarks about, because once the 3346A 210-day limit is expired and the president has not submitted a nomination, the question becomes what happens? 3348B1 answers that question. It says, unless a person is performing in accordance with 3345, 3346, 3347, then the office shall remain vacant, period, full stop. Now, when the Senate originally wrote that provision, they recognized if we say full stop, the office shall remain vacant, then that's going to close the office off permanently and disable the springback that we're contemplating at this time. So they added language saying shall remain vacant until the president submits a nomination. And that's the history and the development of this provision that the Eighth Circuit completely omits from its analysis. It makes it seem as if 3346A2 operates in a seamless manner when it doesn't. When there's a break between 3346A1 and 3346A2, the provision, the penalty provision in 3348B1 comes into play. And that's the principal thing that's missing.
A lot of statutory interpretation comes down to whether Congress used the word and or whether Congress used the word or. And between A1 and A2, there's the word and or, and the word or seemed to indicate the independence of the two periods rather than disqualifying one of the two. It seems to me that the disjunctive indicates the independence. You can serve under A1, you can serve under A2, and there's no statutory language disqualifying you from an A2 service.
Well, Your Honor, again, we're pointing to the language of 3348B1, which intermediates that relationship. But then to speak to your point about or establishing 3346A2 as a disjunctive provision, we're not disagreeing.
Where does B1 come in? Because B1, there's no failed nomination here.
Well, no, what B1 says is that if a person is not performing the functions of this office, the office shall remain vacant. And you look at the drafting history behind that provision, Congress recognized that penalty provision to keep the office vacant.
That's not an issue here.
Well, it is at issue, Your Honor, because when Berry Hill's acting service ended in the
issue because there's no failed nomination, which is what B1 speaks to.
No, Your Honor, B1 speaks to if there isn't a person serving, what happens? And when Berry Hill's service ended in November of 2017, there was no person performing the service, and she affirmatively stepped down from the role of acting commissioner in March of 2018. As a consequence of those two realities, basically the provision, as we understand it, 3348B says the position shall remain vacant, period. And that's the history that the Eighth Circuit glosses over. But let me speak briefly to the or point about these two provisions being independent. It's really important. When you have an either or provision, says you can do A or B. Berry Hill did A. She served 210 days. A or B means you can only choose one or the other. You can't do both. And even in your own reading, Your Honor, of the statute, you find that you have to slip in the word A, the word and to say.
Because
The two prongs of the statute work in tandem and in harmony here in a sense, because A1 tells the president to get on the stick and make the nomination. And A2 tells the Senate to get on with its confirmation process. And that's what those different provisions do. And you can look at them and see that they work in tandem and work in harmony. And what your position would do is you would take a situation where someone like Berry Hill, who had served in an acting capacity, would be disqualified forever after from serving in that active capacity again. And what that does is it destroys a sense of continuity in government, because many, many times the person who is serving the A2 period during a period of Senate confirmation is the person who has the experience as with the acting commissioner's position by virtue of service in A1. And this happens all the time, that someone who has served in an acting capacity then moves out because of the lapse of the 210 days, but then comes back in as a result of the fact that the president made the nomination. And what you do here, if we take your position, is we simply disrupt the continuity in government that's a fairly regular part of the way things work. And we didn't say anything.
Your Honor, may I briefly speak to that?
You can. You've got a lot of time for rebuttal. If you take 13 minutes off at the start, you can go. You've got 7 minutes.
Thank you, Your Honor. I'll speak to the point on rebuttal.
he still has a little bit of time, doesn't he?
Morning, Your Honors. May it please the court, Anna Stapleton on behalf of the government. I can be brief this morning. I would just want to highlight a few points from the plain text that support the clear reading that subsection A2 permitted Ms. Berry Hill's service at the time that she ratified the appointments of the Social Security ALJs. So the plain text of 3346A clearly defines two independent periods of acting service. And there are sort of three textual points that emphasize that. First is that each of the two periods defined have their own start and end dates. A1 runs from the date the vacancy occurs until 210 days thereafter.
Can you talk just a tad louder or put the microphone?
Oh, I
up a little
apologize, Your Honor, of
closer?
course.
Yeah,
Is
thanks.
that better?
Yeah, thanks.
Thank you. So again, A1 has its own start and end date. A2 also has its own start and end date. It runs from the date of the nomination until that nomination is no longer pending. It would be very strange for Congress to have defined A2 to have its own start date if that provision were only ever meant to extend A1. Your Honor, Judge Wilkinson asked about the meaning of or. We would point out that or very commonly has both an inclusive and exclusive meaning. We provided the example of the Supreme Court's decision in Encino Motor Cars.
Language indicating that or means the one to the exclusion of the other.
Exactly, Your Honor. So we look to context. To give an example from common usage, when the waiter comes to the dinner table at the end of the night and asks, would anyone like coffee or dessert?
And the point is to interpret it that way, you simply downgrade the importance of experience in government. You say that, well, because you served these 210 days, she was a deputy commissioner before, and now the commissioner, she has the experience both in a deputy capacity and she has the experience as the acting commissioner. And we're going to say, oh, you can't serve despite the fact that for purposes of continuity until the president does his job according to the statute or the Senate does its job according to the statute, but you really disrupt the whole process of continuity in government and you disqualify people who in more cases than not would be the most qualified to do the job.
That's an excellent point, Your Honor, about the practicalities here. I would also point out that my friend's reading would be in conflict with 3345. 3345 sets out who is eligible to serve. First of all, it doesn't say anything that someone who served under A1 is not eligible to
In
serve.
the absence of a disqualified provision, the or becomes permissive language.
That's correct, Your Honor. It's permissive.
Permissive or.
Absolutely,
And
we agree, Your Honor.
those all the time.
Absolutely, I agree. And
You can do it this way, or you can do it that way, or whatever, but it's permissive or.
That's correct. If I may just make one more point about 3345, it does give the president the prerogative to designate who will serve during the time periods that are defined in 3346. So it turned out that the same presidential order that was in effect when the vacancy first came up was also in effect when Mr. Saul's nomination was made. And that meant that order pointed to the same office, to the Deputy Commissioner for Operations, and Ms. Berryhill occupied that position at both points in time. So to accept my friend's reading would be to contradict the prerogative given to the president under 3345 to make that designation.
Your good opposing number gave that Eighth Circuit decision a hard time. He didn't like it. What do you say?
Your Honor, we think the Eighth Circuit was correct. They made many of the points, they accepted many of the points that we have made in our briefing, including the points about the independence indicated by the word or. Also noted that there is no language in subsection A2 that would somehow suggest that A2 is dependent or conditioned on A1. Another important textual point there, Your Honor, is that the use of the word once in A2, that a person may serve once a first or second nomination is submitted to the Senate, similarly indicates once just means whenever that happens. There's no language there to say that if a nomination is made only during the A1 period, is that A2 period triggered.
In addition to the Eighth Circuit, there are a growing number of district courts also in agreement with your position.
That's correct, Your Honor. The vast majority of district courts have agreed here. And I would note that brings the courts into alignment with the prevailing positions in both the executive branch and legislative branch. So the GAO, which is of course the arm of Congress that is tasked with monitoring compliance with the FVRA, has long stated that once a nomination is made, even if that nomination comes after the expiration of the initial 210 days, it does begin a second period during which acting service is permitted. And again, also, of course, the executive branch, we cited in our brief, the 1999 guidance from OLC, which just shortly after the passage of the FVRA indicated that the executive understood that acting service was permitted once there was a nomination. I'm happy to answer any other questions, but if there are none, I'm also happy to see the remainder of my time, and we would ask the court to affirm.
Thank you.
Judge Wilkinson, I'd like to open with your interrogatory about continuity in government. I appreciate the point fully. Continuity in government is important, but that's not the objective of the Federal Vacancies Reform Act. And let me frame that with a bit of history. For 200 years, this nation functioned under Vacancies Acts that did not provide for 210 days of service and did not provide for a tolling provision during the period of time that a person was serving. From 1795 to 1868, Congress said an acting officer can serve for 180 days, and that's it. After that, if you want someone in the office, you have to nominate someone, the Senate has to confirm someone. From 1868 forward to 1893, that time limit of 180 days was reduced to 10 days. And then from 1891 to 1988, that time limit was increased slightly to 30 days. And then from 1988 to 1998, when the Federal Vacancies Reform Act was enacted, it was increased to 120 days with the tolling provision if the nomination was made during that 120-day period. So if you look at 200 years of unmitigated constitutional history about how this nation has functioned, the Congress has said we can function just fine, and we have functioned just fine through 2 world wars, a civil war, and multiple other major crises.
If it was a constitutional matter, then we could all become originalists. That would be kind of fun. But what we're dealing with here is a present statute.
That's correct, Your Honor. But if the sorry,
what I'm interested in is the present statute, which was enacted with everyday realities in mind. I mean, let's put it this way: the position of the executive branch, the number of offices in the executive branch, all of the confirmation process. All of those things have changed rather substantially since the 1800s. And what Congress said is, these are the present day realities. We're going to enact a statute in response to those realities. And what you're talking about would have some salience if we were dealing with a constitutional provision. We can go back and be originalists, but we have a present day statute.
Your Honor, all
reality.
All of the previous laws that I've been speaking about are not constitutional, they're statutory. The Vacancies Act existed from 1795 forwards. And in all of those preceding laws enacted by Congress authorizing acting appointments, the periods of service allowed under them were much shorter. And they did not say that the minute the president nominates someone, the person can continue to serve endlessly. Now, let me speak.
You're acting as if that last phrase you used about acting as if it continues to serve endlessly. There's nothing in this statute that allows anybody to serve endlessly. The statute says to both the president and the Senate, get a move on. Get a move on.
But your point is, there's nothing that says it wouldn't be endless.
Exactly. And more to the point, the function of reading the statute the way that we describe it is it motivates the president within those 210 days to get a move on and to nominate someone. And that's the key point here. And let me just add, if you adopt the government's interpretation, you run into a number of constitutional problems. And those constitutional problems arise because of this gap in service between when the 210-day limit ends and when the president ultimately submits a nomination, which might be a year later, it could be 10 years later. And those gap periods give rise to constitutional problems because people's lives and their jobs change during that period in time. And if it's simply the case that A2 automatically reactivates a person regardless of those changes, then it's going to be the case that people who are otherwise constitutionally barred from continuing to serve in that acting position because of a change are automatically elevated into that position. Let me give you a very simple example, which we discuss in our reply brief. We give the example of an assistant attorney general who the president decides under the FVRA, I'm going to make you acting attorney general. This person, John Doe, we'll call him, serves for a 210-day period, and afterwards the statute says the office shall remain vacant. The president doesn't nominate anyone. He leaves the office vacant. The Senate is in gridlock, can't do anything. During that period of time, for whatever reason, John Doe gets nominated and confirmed as an Article III judge. That is an office which qualifies under 3345A2. The president can designate someone who is serving in an office that requires a presidential nomination and a Senate confirmation to serve as an acting officer, much as the assistant AG position is. Let's assume John Doe becomes a judge, and the next day afterwards, the president finally submits a nominee for AG. At that point, according to the government's interpretation, John Doe is suddenly attorney general or acting attorney general once again, running afoul of Article III limits, due process limits, and separation of powers limits. So the problem that exists here in saying that acting service doesn't have to be present and continuous under the FVRA is that you run into the gap periods that can create constitutional problems that are otherwise avoided if the only way you can extend a person's service is if the nomination happens during that person's service.
So the practical fallout of this is one thing that concerns me, because I was always in, a lot of judges who were wiser heads than mine have said to me, the first rule of judging is do no harm. Second rule of judging, related to the first, is don't leave the situation in a greater mess than you found it. And the practical implications of this are the precise implications, the number of cases that would be overturned and the rest of that are unforeseeable, but they're bound to be large. And I know you say, well, these practical considerations don't matter, but if you had a stronger case on the statute, that would be one thing, but I don't see it. And so the fact that I can see the practical implications only through a glass darkly, but knowing that they are there, is still a matter of concern, in addition to the difficulties with overturning the Eighth Circuit and the textual difficulties too.
I understand, Your Honor. If I could briefly respond to that. I know my time has expired, but I'll be brief. I understand the concerns that the court has about the practical implications here. Go ahead. Magistrate Judge Schultz, when he wrote his decision in Brian TD, had the exact same concerns. And the government, I might add, posited great practical concerns back when we were dealing with the question of issue exhaustion of these appointments clause claims. None of those concerns came to pass. And more significantly, I don't think that the practical concerns here are significant because of all of the factors that mitigate against a case ultimately receiving relief based on this argument. But putting that to the side for the moment.
I'm going to take all of this up with Congress, because what I'm saying is Congress is in a much better position to clearly spell out to the executive branch how it has to behave than we are. Now, I know what the response is. Congress has already told it. We disagree about that. But at any rate, the proper instrument of control for this is Congress. I think they've said it. I think they've enunciated it.
And Your Honor, I appreciate the point 100%. I think
tell the executive branch how to act. If Congress has told them, we apply the act of Congress to the executive branch.
That's absolutely right, Your Honor. And the way we read this act is consistent with what the Senate report says this act is meant to do, which is to spur the timely and prompt submission of nominations. And respectfully, the act doesn't do that unless the nomination is made during that 210-day period.
Just one question. You were saying that it isn't going to have a big practical effect, right? Just tell me how that is.
Sure, Your Honor. So in a Social Security context, if we're just asking the question, how is this going to affect Social Security claims?
Of course, it doesn't just affect Social Security.
Sure, Your Honor.
I'll let you go there.
But let me speak to Social Security claims. In order for a case to get to the district court level or even to the circuit court level, you need an adverse decision by an ALJ, a timely appeal to the appeals council, a timely appeal to the district court, a district court determination that the case should not be decided on the merits, and a timely appointments clause claim. Those are 5 pretty significant barriers. And when you think about how the Probst litigation unfolded, where the government said the sky will fall unless you impose an issue exhaustion requirement on appointments clause claims. This court rejected that argument. The Supreme Court unanimously rejected that argument. The sky didn't fall. And it's because those same limitations that apply there, respectfully, we submit apply here. To speak to the broader executive.
But I'm not so certain that if we made the decision that you want us to make, certainly all the people that you represent think it will assist them, right?
Well, certainly, Your Honor.
Would.
Well, yes and no, Your Honor. These arguments, it's important to recognize if you have a strong merits argument, you're probably going to get relief faster on that than with one of these arguments, which the government is going to appeal and it's going to take time. So yes, my clients believe that this argument matters, but I think it's equally important to recognize the sky will not fall if the court agrees with the interpretation that we posited here and that quite
So the sky won't fall only because the government's going to appeal petition for cert to the Supreme Court. Is that it?
Well, Your Honor, I think that the Supreme Court, if it were to take up this issue, would agree with our position. And I don't think this.
You don't think everybody is going to be, all of your people that in your client's position are going to be making this argument? It seems to me a pretty sure argument. If the Supreme Court should not reverse us if we went your way, I would think they all would. Anybody that's in this position.
Well, they might try to make the argument, Your Honor, but whether they would be able to do so and whether their circumstances warrant doing so because of those 5 factors that I mentioned a moment ago significantly reduces the pool that is affected by this argument. I hope that makes sense.
I hear you.
Look, I understand that I'm arguing a tough argument here, especially in the wake of the 8th Circuit's decision. But I hope the court can understand we're not making this argument just to frustrate the lives of Congress or the president or anyone else. We're doing it because we believe that's what the statute commands, and that's what the appointments clause in requiring a properly appointed commissioner commands.
Just stating a conclusion, but we understand that.
Thank you, Your Honor. We appreciate the time.
Moving into the next.
Well, we're going to go shake them.
Since we did, yeah.
Send them up to you.
an overwhelmingly male and extremely competitive program within the University of Maryland. She was one of a few women in the chemical physics department at University of Maryland. During her time there, she was accosted essentially by a fellow student that she did not know, who demanded to know why it was that she was excluding him, why it was that she was paying attention to other individuals. And she was left baffled and quite concerned. But at this point, there was no signal that the behavior was motivated by her gender. It seemed like the student who had accosted her was simply disturbed in some way.
When did the signal come that the behavior was motivated by her gender in your view?
In my view, it begins with the text messages. And I believe that
So in May?
Yes. What Ms. Luskin described as the flood of text messages and University of Maryland.
Can you put that for me in the context of she's making several reports to the university? And what that was the trigger of which report? The fourth?
That was the trigger of the second report. The first report, I believe, the first report related to an outburst that he had with Ms. Luskin and several other students when he believed that they were making fun of him. And I believe that the text messages are found at 574 in the joint appendix. And I believe that if one reads the text messages, the male student being the white, it becomes very apparent he is commenting on her boyfriend, on her relationship status, on her ring.
What are you talking about now?
The text messages.
Where's the text message?
The text messages begin at Joint Appendix 573. And
well, when she reports about the second incident, it's JA 556. So the second incident is before that.
The second incident is April 12th, 2018.
Yes.
And she was cornered alone in her office.
Right.
I think
The third incident is May.
I apologize, Your Honor. I believe I transposed the two events. In any event, her initial report went to what is called the beta team. The beta team is a non-disciplinary body that essentially looks out for students who are in some sort of.
But and you're welcome to do this any way you want to, but when do you think that the university became liable because it was not properly responsive to her complaint? In responding to which complaint?
When Ms. Luskin returned to the administrator of the beta team and was then sent to the University Counseling Center, she was directed to the Title IX office, which is how it's commonly known, to file a report of harassment based on gender, because the counselor clearly saw that it was gender-based behavior. The university initially sent the male student a letter saying, "You are accused of sexual misconduct. It is abundantly clear." At this time, the director for the Title IX office and the non-harassment disciplinary office was the same person. And this complaint was initially treated as a sexual harassment complaint. It was then changed in contravention of the clear language in the policies relating to sexual misconduct that UMD abides by. And it was dealt with as a disciplinary matter in the way that a personal dispute would be done. For example, two roommates who do not get along.
And the response to that was no contact.
No, a no contact order, Your Honor, was issued, but a no contact order at the University of Maryland does not mean no contact, it means no communication. So unlike a peace order, which she was given by the district court, it does not prohibit the male student and Ms. Luskin from being in the same room, from
That's fine. Okay, I understand that. So what, was it possible that she also would have gotten as her relief a no contact order if it had gone through the group that you thought it should go through?
The Office of Student Conduct is the body that grants no contact order.
I don't understand. What could the Office of Civil Rights and Sexual Misconduct have done? Could it have issued a non-contact order?
It could have requested, and it did request, a no contact order, what they call a no contact order, from the Office of Sexual Misconduct, and that no contact order did issue. He was prohibited from communicating with her.
Okay, though that's what happens with the third incident. So is the university somehow liable for being under the law, not responsive to the third incident?
Well, I believe at that point, yes.
Well, I thought you just told me that if the group that you thought it should go to, the Office of Civil Rights and Sexual Misconduct, can direct a no contact order.
And request a no contact
Okay,
order.
could request one, but she got it.
She got it by complaining directly to the Office of Civil Rights and Sexual Misconduct. At that time, the individual who was administering this changed it from a Title IX complaint to a simple discipline complaint. There was no Title IX investigation. There was no Title IX hearing. There was no finding of facts. There were none of the procedural safeguards.
You're placing your emphasis on the way in which the order was routed to whatever university or body or community was routed, rather than on the response of the university as a whole?
No, Your Honor, and I appreciate the direction, because our claim is the district court found that the harassment was indeed severe. So there was enough evidence in the record that it was severe and pervasive, and yet found that even though Ms. Luskin dropped out of the program, moved across the country, and restarted the program in California, there was no concrete negative effect on her access to educational opportunities, and actually no denial of equal access to educational opportunities. And I think that the idea that it could meet the elements of severe and pervasive, and that a student would seek mental health treatment based on this, would take a master's in chemical physics, which is equivalent to going to law school and leaving with a master's. It's not a degree that has any market value, and leave the university. Well, I mean, it is a master's in chemical physics. There's no attendant job for that. So
I mean, I'm not sure how this argument helps you, but go ahead.
Okay. The reason that she took.
We agree with you on the severe and pervasive and that it impacted her education. You still need to get over the hurdle of how the university's response was clearly unreasonable. Am I right about that?
Yes, absolutely.
Okay, so how do you get us there?
So the district court focused on the administrative procedures that the school followed.
Well, this is exactly what you were focusing on. So it's understandable why the district court would do that. Remember our whole discussion? You were just going about it had to be one department, not the other.
I understand, Your Honor, and there are many ways to have a reasonable response to sexual harassment that leads to gender discrimination. What they did was grant a no contact order and essentially leave her to her own devices to set up accommodations with individual professors, which she did. So if a no contact order is issued, and a student is acting violently, screaming, hands in pockets, has come by a tiny office to berate Ms. Luskin about having reported him, then there has to be some action other than what is essentially some form of double secret probation, where he was told, well, if you do it again, then you will be in real trouble. So he does something which is clearly meant to intimidate this female student. He continues on that course of conduct. He is
At the bottom, I mean, the Davis decision says the question is one of deliberate indifference. And you may disagree with what office they reported it to and how it was routed. And of course, I think that, I mean, I can see a lot of reasons why this would be funneled through student misconduct rather than the rather than the sexual misconduct. But if there's a deliberate indifference standard, even without getting into deliberate, I don't understand where there was indifference at all. You're having two different contact orders and you're talking to the professor. And then when there was a violation of the no contact order, further disciplinary steps were taken. I don't understand why there was how that was indifference, much less deliberate indifference. It seems to me there was deliberate attention paid to what is a very unfortunate problem.
I believe that when Ms. Luskin made her report to the Title IX office, and the intake individual, the only person in that office, looked her in the face and told her, and this is in her deposition at J692, told her that she had to go to the district court because there was nothing that he could do for her. And she had just been essentially threatened with angry, violent behavior in her office, and then followed by that same individual as she walked across campus to report the behavior that he had just committed. I think that saying that someone is obsessed with you and threatening you and making it, and I'm not talking about the feeling unsafe, I mean physically unsafe. She was reasonably in fear for her physical safety. When the university says to you,
I get you to this extent. I think it's a very unfortunate problem, and it was important that the university be responsive here. But I don't understand how you can say, for example, just to take one part of a larger response, that the university was indifferent because when the no contact order was violated, the university barred CH from attending classes and entering academic buildings and labs, and it placed him, sanctioned him, placed him on disciplinary probation. And it says, at least your opposing counsel indicates, after these actions actually proved successful because Luskin had no contact or interaction with CH after he violated the no contact order. But what they're trying to do is one thing after another, and you may not agree, but how is it indifferent, much less deliberate? That's the standard we're talking about. We're not talking about
ineffectiveness.
And the Supreme Court's definition of deliberate indifference as clearly unreasonable. I do believe that it is clearly unreasonable for there to be discriminatory behavior based on a student's gender. So this action from this male student towards my client was based on her gender. And the school will say, we're going to tell him to stop. And it's not lewd comments. It is angry,
violent, intrusive behavior, merely asking a student to behave himself, and then when he doesn't, barring him from campus until he meets with the Title IX coordinator. It was a day or so. It was not a stretch of time. She still saw him on campus. She still ran into him. And ultimately, she believed that the behavior was escalating, because it was, and the university's response was not escalating. He was told not to contact her. He violated that. And he was told again not to contact her. That was all. And I believe that that is clearly unreasonable given the known circumstances. I'm sorry, I've gone over my time.
Thank you.
May it please the court, Catherine Bradley for the University of Maryland, College Park. This court should affirm the district court's decision granting summary judgment to the university because viewing the facts and evidence and inferences in light most favorable to Ms. Luskin, no reasonable juror could find that the university was deliberately indifferent to sexual harassment, and no reasonable juror could find that CH's conduct deprived Ms. Luskin of access to educational opportunities or benefits. Far from being deliberately
Okay,
indifferent.
just a minute. And you added a clause, and if we should find that they did deprive her of the education, whatever the end of the and sentence was, where does deliberate indifference go?
So I stated that because that was what the district court found, that she, the university, CH's conduct did not deprive her of educational opportunities and benefits. Even if you find that it did deprive her of educational opportunities and benefits, the next step in the analysis is whether or not the university's response was deliberately indifferent or clearly unreasonable. And so those are separate parts of the analysis. And certainly we do not think that the university's response was deliberately indifferent.
What was the university's response after the April incident when he cornered her in the office?
After the April incident, Ms. Luskin and a male student reported the conduct to the beta team. And prior to that, they had asked that the report be confidential. I believe at that point, the beta case manager reached out to 5 of CH's professors to ask if they had concerns about CH, and none of them did. And that was the time when the university permitted Ms. Luskin to move offices so that she would no longer be in contact or share an office with CH.
And at that time, she and the male student had requested that the report be confidential. Is that what you said?
I know that at the time of the February incident, which definitely didn't target Ms. Luskin in particular, that Eli Mizrachi had asked that be confidential. I'm not entirely sure if they had asked at that point that the April conduct be confidential, but that was, again, Ms. Luskin did feel threatened, but it was a conversation in a shared office in which CH felt angry and angrily expressed his exclusion. He didn't follow her and he didn't say anything sex-based at that time. And they reported to the beta team and the police.
Follow her, because I thought opposing counsel said he did follow her across campus to where she went to report it.
That not in April. He didn't follow her at all in April. In opposing counsel and in the record, their testimony that he circled at a distance when Ms. Luskin and others went to go report the October 15 violation of the no contact order.
2 incidents later.
Opposing counsel also said something like it was only a day or so that they banned him from campus or banned him from classes or something. Could you respond to that and put it in context? I mean, the university did more than just ban him for a day or so, correct?
Right. So after he violated the no contact order in October 15, 2018, the university immediately contacted him, and CH told him he was barred from attending classes and entering academic buildings, ordered him to meet with Dr. Goodwin, and which he did. And he met with Dr. Goodwin and Sergeant Mabel. And then he was ordered to be evaluated by a psychiatrist, which he also did. Then Dr. Goodwin implemented a safety plan so that CH would not come into contact with Ms. Luskin, required that he take classes that he shared with her online, barred him from—
When was all that? That was in October or in May?
October.
Right. And in May, 2 days after the May incident, a no contact order was put in place then, wasn't it?
Right, May 10. So the May 8, the text messages occurred on May 8th. She reported to the OCRSM, the Office of Civil Rights and Sexual Misconduct, on May 9. That is when the director of that office, Ms. Carroll, conducted an initial assessment and determined that the conduct was not sex-based and did not fall under the sexual misconduct policy. So she referred it to the Office of Student Conduct, but at the time she referred it, she also asked for a no contact order. And the Office of Student Conduct is the only office that has the authority to issue no contact orders.
So
and then
even
they did
if
issue
she
it.
put it to the Office of Civil Rights and Sexual Misconduct, in order to get a no contact order, they had to go to the Office of Student Conduct.
Yes, it has to be, that's the only office authorized to issue those orders. So it has to be at least, routed through that office to get the no contact order. And then at that time, after the May 9 incident, or the May 8 incident, the no contact order was issued on May 10. And then Dr. Goodwin met with CH for over an hour to explain the no contact order, to explain Ms. Luskin's complaint. And CH also met with Dr. Zacher, who is the AVP of Student Affairs, to address Ms. Luskin's complaint. And CH admitted to sending the text messages, and agreed to comply with the no contact order. And after that, the university also made their shared professors aware of the no contact order and permitted Ms. Luskin to take exams and complete projects apart from CH. This action, these responses by the university were not clearly unreasonable. And the Supreme Court, as we talked about in Davis, said that an educational institution can be liable for sexual harassment being deliberately indifferent only when its response is clearly unreasonable in light of the known circumstances. The Davis court made clear that that can be decided on a motion for summary judgment, and to the extent that Ms. Luskin argues otherwise, that conflicts with Davis. Here, the university responded to all of Ms. Luskin's reports in a manner reasonably calculated to end the unwelcome behavior and maintain Ms. Luskin's access to her education. Ms. Luskin argues that the university was deliberately indifferent by not applying the sexual misconduct procedures and instead applying the regular student conduct procedures and policy. But as we argued in the brief, that classification was not clearly unreasonable. Multiple university administrators, Drs. Goodwin and Zacher and Ms. Carroll, all agreed that CH's conduct was not based on sex. In addition, male students, Donnie Pearson and Eli Mizrachi, had also felt targeted by CH. And second, as we've been discussing, the classification as regular student misconduct did not impact the effectiveness of the university's response as a whole. And that's what matters in Davis. It doesn't matter which office it went through, whether it went through the Title IX procedures. It just matters whether the university's response was clearly unreasonable in light of the known circumstances. In addition, the university—
Does this directly speak to different offices?
It does not speak directly to different offices, but there are cases that make clear that failure to follow Title IX procedures or Title IX regulations is not indicative of deliberate indifference, including Gebser.
I guess you made the point that the Title IX procedures can be very bureaucratic, and the Office of Student Misconduct would still have jurisdiction and can move in a more expeditious and informal manner to grant effective relief.
The university, that point was made. Dr. Goodwin testified that the response was largely the same, and it was faster under the OSC rules. Didn't really even need to be an investigation because CH admitted to the conduct. But if they had viewed this was really sexual misconduct, they would have routed it through the Title IX procedures, no matter how much more bureaucratic and long, difficult that was. Ultimately, the response, again, was largely the same as it would have been. They issued the no contact order. The university talked to the parties and their professors to ensure that they remained separate and apart. And They also implemented various protective measures, including, Ms. Luskin talks about the university left her to her own devices to set up accommodations. The way accommodations work is that you request them. And that's what she did, and they were approved in every case. I think there was one case where she wanted to have an accommodation, or she wanted to take a final exam apart from CH. That was denied, but instead she got assurances that a professor was going to be present for the entire time, and there were no issues.
Can I ask you about the fourth incident? Because that was the one that really nobody talks very much about. But so there's this note, he's under the no contact order, and he's angry, and he confronts her. And so she goes to administration, and the Title IX offices recommends that she seek a peace officer from the Prince George's County Court. That doesn't sound to me like, you have to, that's not exactly, a person receiving that might well think that the university was just putting this off on a different agency or a different, we can't do anything for you, so go somewhere else. Can you speak to that?
Yes. My understanding was that Mr. Nelms told Ms. Luskin that she should seek a this peace order if she wished to have protection off campus as well as on campus. So, the university didn't have control over what would be going on off campus. And in addition,
did he say anything like, and we will support you on that?
Yes. It was recommended by him. So and she followed that recommendation.
Well,
and they did support him on that.
Did the police know that? She knows that they're supporting her on that. Do you understand what I'm saying?
Did the police know that? Is that what you said? Oh,
that the university was supporting her in seeking this, because it seems to me, if I am, or my child is suffering this, and they go to the university administrators say, well, go to the police. That doesn't seem to me to, maybe that's good advice.
It's not, I'm sorry.
Go ahead.
That's not the only thing Mr. Nelms did, but he did suggest that she could do that to obtain protection off and on campus. She also reported the conduct to the police. And when it was reported to the OSC, immediately they took action in terms of barring him. He told him he couldn't go to class, couldn't go on campus, couldn't go to this academic building until he met with Dr. Goodwin. And there's a portion of the record where Dr. Goodwin asking if, do you know if he threatened her? If so, I would like to do an interim suspension. But there was no evidence. It appeared that he actually threatened her. So he, didn't do an interim suspension at that time. That's on JA 724. So, the conduct, even if you just look at the conduct that's at issue here, yes, it's angry, it's unwelcome, but it's not clearly threatening, and it's not clearly severe and pervasive and objectively offensive, such that it interfered with her educational opportunities or benefits.
Well, does she ever assert, and I couldn't find this, that the advice to get the peace order was inappropriate or wrong or impossible, or she couldn't do it, or not responsive to her needs?
As far as I know, she does not assert that. And the university, after they got the peace order and were aware of it, worked to make sure that it was, that everybody followed it. CH ultimately accepted a final peace order and, told Dr. Goodwin and others and Sergeant Mabel what the terms of the final peace order was, committed to complying with it. And they worked together to ensure that they complied with it.
The peace order is to handle things outside of campus.
That's my understanding.
Because that's why you had to go to the police for it. As opposed to what the university was doing within the campus.
My understanding is that she went to the police, to OCRSM, and then they spoke, after speaking to OCRSM, went to the district court to obtain a peace order.
To the federal district court? No.
To I believe the state district court. Yes, Maryland State District Court. So the university's actions here were reasonably calculated to end the unwelcome behavior and maintain Ms. Luskin's access to educational benefits, and they were successful in doing so. After the October 15 incident, when CH violated the no contact order, there were no
further interactions between the two, no further issues for about 7 months. And Ms. Luskin did, the district court properly also found that the CH's conduct did not deprive Ms. Luskin of access to her education. I mean, Ms. Luskin argues that CH's conduct had a concrete negative effect on her education because she left the program with a master's degree. She voluntarily left about 7 months after the last incident. And that was after finishing both the fall 2018 semester and the spring 2019 semester successfully with good grades. And she also decided to re-enroll in the university's PhD program. She made that decision in the fall of 2019. I believe she re-enrolled sometime in 2020. She's currently still enrolled in the PhD program at the university. The cases in which courts have found that and sent to the question to the jury about whether voluntarily or leaving a program creates an issue as to deprivation of education access, like Zeno in the Second Circuit and Vance in the Sixth Circuit, those had ongoing harassment until the person left the program. She also argues that she experienced anxiety and fear on a regular basis, but she doesn't describe how that anxiety and fear had a concrete negative effect on her ability to participate in education program or activity, like, for example, causing her to have to miss classes due to the anxiety and fear. And finally, she also argues in her reply that she had to switch offices and change the way she took exams and gave presentations, but it's not clear at all how those negatively affected her access to education, as those were measures designed to ensure that she had continued equal access to her education. And those are things that the university implemented. Because no reasonable jury could find that CH's conduct deprived Ms. Luskin of access to educational opportunities and benefits, the court can affirm on that additional ground that the district court found. The court can also affirm on the alternative reasons that CH's conduct was not severe, pervasive, and objectively offensive and was not based on sex. Cases that have severe conduct, usually it's physical conduct like assault, battery, sexual assault, of course, none of that's present here. But if there's severe verbal conduct, it's verbal threats of physical injury, derogatory, hateful comments like those in feminist majority, or profane, humiliating, degrading comments like those from the coach in Jennings. It's usually widespread verbal conduct, like it's persistent, hundreds of messages or comments or daily interactions. None of that's present here. And Ms. Luskin did not actually ask CH to stop contacting her or stop speaking with her until after she reported it to the OCRSM on May 9. And after that was when the no contact order was issued on May 10. There's no sex stereotyped or sex-based comments, no daily messages or phone calls. He didn't follow her around.
Well, eventually he's talking about her boyfriend. And so I'm not so sure that you could say there are no sex-based comments.
I would say that it's unreasonable to infer that just because after she voluntarily brought up her boyfriend, she asked a couple of questions about their relationship. This is not a case like those where, a Title VII hostile sex-based harassment, like Livingston v. Marion Bank and Trust.
It's not like those cases, but you said I thought you said that there was no sexual contact here, or no element of sexual harassment here. And I think there is later on, as case goes on, in the contacts between the two of them, there is some element of it.
The cases that find I didn't see anything cited by Ms. Luskin. The cases that find that there's actual sex-based conduct or that it's a jury question that he cited about, the cases that were cited were all like Title VII cases in which you had oftentimes an employer asking questions of an employee. So this is different from a case where you have a supervisor asking sex-based questions about his employee, about the sex life with her husband and things like that. These are two peers. And again, there wasn't anything about sex. It was about, he did ask questions about her boyfriend, but that doesn't indicate that his contact with her was due to her sex or due to sexual desire.
Well, I don't know. Things may have changed since I was young, but somebody asked you if you had a boyfriend. That indicated to me that they had some interest in you. that was not purely platonic.
Your
Put it
Honor,
that way.
I will respectfully submit that he didn't actually ask if she had a boyfriend. He did make a comment about her
I don't
ring.
think I'd quarrel about it. The record is what it is.
So,
You have to live with it, just as they do.
but again, this court should affirm the district court's grant of summary judgment because for the university, because viewing the facts and evidence in the light most favorable to Ms. Luskin, no reasonable juror could find that the university was deliberately indifferent. Thank you.
Thank you. Paul?
Thank you. I want to address the no incidents for 7 months. The individual was in Europe at the time. He
The
wasn't
plaintiff.
And so, the school cannot point to his involuntary absence from campus as evidence that the measures that they have instituted are effective. I would also, on the question of her interaction with Mr. Nelms, again, direct the court to JA 691 through 694. She has been in violation of a no contact order in the cell phone proof basement of a laboratory. She has just had an individual burst into her office and start angrily talking to her through another individual who's present with his hands in his pockets. He then follows her as she goes to report him to the police. When she arrives at Mr. Nelms' office, according to her, and this is the evidence that's in the record, he said, you're really in danger and you can have a peace order hearing and get some protection, like something along the lines of that. That's going to be something that will protect you more than whatever we can do here. Well, that's not the school has the authority after someone violates a no contact order and then follows someone in a clearly intimidating manner to say, you're barred from campus. You have to do online. You have to do certain things. It was Miss Luskin who had to change offices. It was Miss Luskin who had to, and counsel is correct. She is enrolled in University of Maryland in California. She is studying at the Joint Propulsion Laboratory for NASA. That is where she is doing her work. She did re-enroll with University of Maryland. It is extraordinarily difficult to begin a PhD program at one university in such a specialized topic and move to another. She, on her own, found a research partner, a topic, got funding for it, re-enrolled, moved to California, and resumed her studies. I think that the question of deliberate indifference and whether or not something is clearly unreasonable is whether or not it is essentially a half-hearted attempt, as the court found in feminist majority, that is not effective. I think that there has to be something more than saying
the fact that a response is graduated and sort of goes step by step after the initial no contact orders proved to be less than effective, but the fact that a response is graduated doesn't mean that it's deliberate indifference, because most universities would respond to these kinds of things in a graduated manner.
I believe that progressive discipline would be an appropriate response, but it has to be progressive. She went from a no contact order to, hey, you need to go to the police because we can't do anything from you. There was no change. The university took him out of school until he had a meeting and made a note in his file. That is administrative. It's essentially window dressing. And if universities are able to hand people pieces of paper and take no further action when they are acting in a manner that I fundamentally believe would deny.
But the university talked to professors to make certain that they were aware of the no contact order.
She talked to professors. The beta team initially inquired to his professors as to whether or not he was okay. So the initial response was towards his well-being, not hers.
Well, or his mental state. You know.
No,
I mean, if they had never contacted him, you would be telling us, well, they weren't dealing with the root of the problem. They were just focusing on the poor victim.
But this is not a case. Look, you cannot require that a university prevent all gender discrimination. It is not going to happen. But if there is violent, gender-based behavior, threatening behavior, scary behavior, you have to do more, in my mind. I believe that it is clearly unreasonable to simply say, well, we told him to stop, he broke that. So we told him to stop again. That is effectively what happened, and that is why she left the campus.
All right, thank you, counsel. We will
We'll go down.
wave
Talk
hi
to him.
to you or shake hands, and then we will adjourn for the day. Well, I guess until this afternoon.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Thank you so much.